Okay, hello everyone and welcome. My name is Jennifer Nelson. I'm going to be your presenter today for the Form I-9 Overview webinar. I'm here with my colleague Janelle Harries, and I've just put everyone in a listen-only mode so that we can avoid any background noises or sounds during the presentation today. However, we do want to make this as interactive as possible. So if you have questions during the presentation or you're having technical problems, please send those questions or issues through the notes feature of our system. There's a note icon near the top of your screen right around the arrow I just drew, or you can use the note tab in the upper right-hand corner of the screen next to the participants tab. If you could please send those notes to the USCIS Form I-9 host account, we'll go ahead and get those Q&A answered for everyone today. Janelle's going to be on those questions today. Janelle and I are both part of the Outreach Division here at Verification, which lives, I guess, within the U.S. Citizenship and Immigration Services under the Department of Homeland Security. We're going to talk a little bit later about some of the services that we can provide to associations and employers. Also, everyone's going to receive a copy of the PowerPoint presentation today. I'll be sending that out shortly after the webinar. You can expect that probably within an hour after the webinar, and I'll be emailing it out to everyone to the email address that you logged in with today, so you can be watching for that. Towards the end, I give you a lot of resources, phone numbers, email addresses if you need to contact us after the webinar. So don't worry about jotting any of those down because you will receive a copy of the PowerPoint slides. And I think with that, we'll go ahead and get started with the Form I-9. So the agenda for today is that we're going to go through a brief history and background of how the Form I-9 came about, and then we'll step through the nuts and bolts of the form by breaking it down piece by piece. As many of you probably already know, and perhaps why you're here today, the form was recently revised and now has a revision date of March 8, 2013. It was released for use as of that date, March 8, 2013, and at the time had a 60-day transitional period for employers to implement its use. Now that 60-day period ended, and as of effective May 7, 2013, no other versions of the form could be used for new hires or revisions. We will talk during the presentation about retention and storage of the Form I-9, as well as some resources that I talked to you about earlier, those phone numbers, email addresses, and some websites that you can visit to get additional questions answered after the webinar today. And then finally, we will talk a little bit about the E-Verify program. And for those of you who have not yet been introduced to E-Verify, it is a free online system that allows employers to electronically verify employment eligibility of new hires. And we're going to touch very briefly upon that program, and we have webinars specifically geared towards E-Verify as well, so we're not going to get into great detail about E-Verify, but we will touch upon it so that you can become a little more familiar with it. So the logical place to start our discussion today is with the background. And as employers, you are using the form each time you hire a new person to work for you. So it is important to understand the laws that created the need for employment verification. Today I'm going to give you a very condensed version of those laws, and that is that in 1986, Congress passed the Immigration Reform and Control Act known as IRCA. IRCA states that no employer is allowed to knowingly hire workers who are not legally able to work in the United States. You can find the employer sanction provisions created by IRCA at Section 274A of the Immigration and Nationality Act, sometimes referred to as the INA. IRCA established 4 categories of individuals who can legally work in the United States. And for Form I-9 purposes, when I'm referring to the United States, it might be a little more inclusive or a larger area than what you may normally think of. So for Form I-9 purposes, that term United States includes all 50 United States, Washington, D.C., the U.S. Virgin Islands, Guam, Puerto Rico, and the Commonwealth of the Northern Mariana Islands. So you kind of want to keep that in mind when we're talking about the Form I-9. So those 4 work-eligible categories are citizens of the United States, obviously the first one shown here, and these are people who were either born in the United States, naturalized, or even derived that citizenship. The next category down are non-citizen nationals of the United States, And these are typically people who were born in the American Samoa, including Swains Island, and they owe allegiance to the United States but don't have certain rights, such as the right to vote in the United States. The next category are lawful permanent residents, and these are our green card holders. And the last category are aliens authorized to work. And you may hear of these folks referenced as non-citizens authorized to work. And they are a category of work-eligible individuals that do not fall within those top three categories. So they would be aliens authorized to work. And they might be a temporary status, maybe a student that does have that work authorization. So there's a few things that as an employer you need to do in order to comply with the employment provisions of the Immigration and Nationality Act. You must verify the identity and the employment authorization documents provided by a new hire, and then complete and retain a Form I-9. Now this is going to be true for all employees hired after November 6th of 1986. And when completing this process, be sure to refrain from discriminating against individuals based on their actual or even their perceived national origin, citizenship, or immigration status. And to describe that a little bit further, when I say actual or perceived, I mean that you don't want to use your own judgment of what you think a legal worker would look like or sound like. Obviously, none of us can tell a legal worker just by their appearance or their accent or even their country of birth. You always need to look at the facts, not the faces. Look at that documentation that they've provided to you. Also, employers are required to do the Form I-9, and here at Verification, we want to make sure that you have the tools and the information needed to complete the form correctly so that you can avoid any penalties. It's very important to properly follow the Form I-9 process because not doing so could potentially result in civil or even criminal penalties. I am getting a little bit of background noise, so I'm going to go ahead and take everyone out of that listen-only mode and try to put you back in just to make sure that we don't get any background sounds.
All participants are now in interactive talk mode. All participants are now in listen-only mode.
Looks like I am now in listen-only mode. Okay, there we go. As a backup, if everyone could put their own phones on mute, sometimes we do have technical problems with that listen-only mode feature of our system, and if you could put your own phones on mute, that does help avoid any of those distracting background sounds. If your phone doesn't have a mute button, you can press *6, and that will also mute your line. Finally, if you've joined us with a headset, you can use the mute icon near the top center of your screen, and that will mute the microphone on your headset. So I apologize for that delay there. I just want to make sure that everyone can hear us very clearly. Okay, so we talked a little bit about the anti-discrimination provisions of the INA on the last slide. The first two shown on this slide are the ones we touched upon very briefly, that citizenship or immigration status discrimination or national origin discrimination. And remember, both of these are either actual or even perceived. The last two are document abuse and retaliation. Now, I'm going to go into a little further detail or an example of each of these to make sure that everyone's clear on what they actually mean. So an example of document abuse is if an employer asks for a specific document or more documentation than what's actually required by the Form I-9. So basically, you cannot tell an employee, hey, you start work tomorrow, why don't you bring me your driver's license and your Social Security card so we can fill out that Form I-9? That's unacceptable. You cannot do that. You must provide all employees, new hires, that list of acceptable documents. From the list of acceptable documents, they can choose which document from List A or combination of B and C documents they wish to provide. That must be the employee's choice. An employer cannot dictate which documents must be presented. And then finally, retaliation. An example of retaliation would be if an employee testified on behalf of another employee who had filed a lawsuit or maybe a grievance, and based on that action, the employer then begins to take negative actions against the employee. This type of behavior is also prohibited by the anti-discrimination provisions of the INA. Those provisions of the INA are enforced by the Office of Special Counsel. We refer to them as OSC, and they fall in the Department of Justice's Civil Rights Division. They have two phone numbers available, one for employees and the other for employers, Employees can contact the Office of Special Counsel if they feel that they've suffered discrimination, or maybe they just need a little more information about their rights during the employment verification process. The second phone number found at the bottom of this slide is for employers. And this is where an employer can call, even anonymously, and speak to an OSC representative directly. Maybe you have a scenario where you feel action is necessary, you want to make sure that you're within your rights as an employer. You can contact them, make sure that you won't be out of line in taking the action you are considering. Really, they'd much rather assist you in doing the right thing up front than having to answer to a complaint of discrimination later. That's what this resource is for. They want to make sure that they are available to assist you. All right, at this point, I'm going to take a little pause and send everyone a poll question. We're trying to get a more accurate reading of the number of people participating in our webinar today. We understand that you may have more than one person in a conference room or gathered around a computer, so we're just trying to get a sense of the number of participants we have today. Now, if you've joined us as a web application participant, you will not be able to see or respond to the poll, but don't worry too much about that. It's really just an estimate for our use. Also, if you joined us late and you didn't hear the instructions at the beginning, you will be receiving a copy of the PowerPoint, so be watching for that in the email address that you logged in with this afternoon. And if you have questions during the webinar, please address those to the USCIS Form I-9 host account, where my coworker Janelle is going to be assisting in answering those questions. You can use the note icon towards the top of your screen right around this location, or the Note tab on the upper right-hand corner of your screen to send those notes and questions into us. And we'll take a couple breaks during the presentation to go through those Q&A that have come in. All right, thanks for answering that poll. Let's move on now to the Form I-9 itself. So here we have a couple screenshots. This is the Form I-9, the revised Form I-9. It is now 9 pages in length total. Here we have a look at the Form I-9 portions that require completion. So this is going to be sections 1, 2, and 3, which are found on pages 7 and 8. Page 9 is the list of acceptable documents. As you can see, the form is now 2 pages in length that you'll be completing with 6 pages of expanded instructions. Section 1 is now 1 full page in length, and it does have a stop sign at the end of that portion to signify the end of the employee section of the form. You'll see that stop sign right down here. Now, the Form I-9 is available in English and in Spanish. The Spanish version can be used as a translation guide anywhere in the United States or our territories, but Puerto Rico is the only location that can use that Spanish version for completion and retention. Everywhere else can only use the Spanish version as a translation guide. You should be using the English version for completion and retention. And when you're providing the form to an employee to complete, you must ensure that all of the instructional pages and the list of acceptable documents are also made available to that employee. Now, the only pages that require retention are the pages that you're completing. So it's going to be pages 7 and 8 that do require retention. You can also choose to print the form double-sided in order to save paper and to eliminate the possibility of the 2 completed pages from becoming separated. All U.S. employers must have a Form I-9 on file for all current employees. The exception is for employees hired on or before November 6 of 1986. As you might remember from that brief background we went through, that IRCA had not yet been enacted in 1986, so the rules were not yet in place. Those people hired prior to November 6 of 1986 who've never had a break in their employment service are grandfathered in, and they don't need to have the Form I-9 on file for those folks. Now, you may delegate the authority to complete the Form I-9 to a responsible agent. However, you will retain liability for errors. So, in other words, if someone is designated to act on your behalf, you as the employer are still liable for any errors that might be made. So you want to make sure if you're designating someone else to act on your behalf that they do understand the process and regulations associated with the Form I-9's completion. Here are a few exceptions as to when the Form I-9 is not required to be completed. The first one are individuals employed for casual domestic work in a private home, and that work is completed on a sporadic, irregular, or intermittent basis. The next one down are independent contractors. An independent contractor is not considered an employee for Form I-9 purposes and does not need to complete the Form I-9. So an independent contractor includes individuals or entities who carry on independent business or contract to do a piece of work according to their own means and methods. Basically, you are not setting their work hours or providing them the tools to do that job. And then finally, if you have employees working outside of the United States, you do not need to have a Form I-9 on file for those individuals. And remember, again, for purposes of the Form I-9, when we're talking about the United States, it's all inclusive of these areas shown at the bottom of this slide. Now, in the event of a merger or acquisition, you do have two options as to how you will treat those acquired workers. Your first option is to treat the workers as newly hired employees and complete new Forms I-9 for all of those workers. Your second option is to consider them as continuing in employment and therefore retain the previous Forms I-9 that were already completed. In this scenario, you will also retain any Form I-9 liability for previously made mistakes. So as kind of an additional point to think about with option 2 is that you can go ahead and complete an internal audit of those previously completed forms and go ahead and make corrections as needed. And we are going to talk a little bit later about how to properly make corrections on the Form I-9. Now, in the case of a merger or acquisition, what's important to remember with either option is that all acquired employees should be treated the same in order to avoid discrimination concerns. You cannot be selective and choose option 1 for some employees, option 2 for other employees. You must be consistent and use the same option for all of those acquired workers. Here we have a screenshot of the list of acceptable documents I mentioned earlier. Again, you must make the list along with the 6-page of instructions available to your employee when he or she is completing the Form I-9. From this list, he or she can choose which List A documents or combination of B and C documents they wish to provide in order to prove their identity and their employment authorization. Again, as an employer, you cannot dictate which document or document combination the employee must provide because that would be considered document abuse and it is prohibited by those anti-discrimination provisions of the INA. I want to point out a couple things that might look a little different to you on the list of acceptable documents. These were made with the recent revision to the form. You'll see that number 5 under List A has been reworded to make it clear that this document combination includes a foreign passport and an I-94. Also, number 1 under List C has added language to the description of a Social Security card to identify which printed restrictions make that Social Security card unacceptable for Form I-9 purposes. You also always want to make sure that you are providing the most current version of both the form, the instructions, and the list of acceptable documents to your employee. And remember, the most recent version is March 8, 2013. That revision date is shown right here. Okay, so here we have a screenshot of Section 1, a portion of Section 1 of the Form I-9. And to align with cultural standards, the name fields now have a further description, including family name and given name. The maiden name was replaced with other names used, and the employee should input NA if there are no other legal names that they have used. The form instructions state to enter NA if the employee does not have a middle initial or other names used. The employee should enter their name as it appears on their documents. Nicknames should not be used. And you'll also see that the form has a 9-digit entry for the Social Security number right here. And this will help to avoid entry errors of that Social Security number. Now, for Form I-9 purposes only, the Social Security number is optional, but does become mandatory if the employer is using and enrolled in E-Verify. You'll also notice an email address and telephone number boxes directly next to the Social Security box. These are optional fields, and the instructions indicate that the employee may enter NA in these blocks if they choose not to provide this information. However, USCIS does recommend that the employee mark NA if they choose not to provide, because it will help show that the blocks were left blank intentionally and not simply overlooked when completing the form. I want to tell you that the benefit of these two new boxes is an effort under development here at Verification, which is the ability for employees to receive an email alerting them that they've received an information mismatch by their employer who's using E-Verify. Really, the feature is going to be an added benefit to employees as a secondary notification of a tentative non-confirmation. But again, that's under development. It has not yet been implemented. Now, due to CBP's I-94 automation initiative, some employees may present you with an I-94 document that's a little different than what you are used to seeing. So we've provided some examples here. Many employees will still present that cardstock I-94 that you're used to seeing. However, some may present an I-94 with the printed number crossed out or provide the admission information as a computer printout. So our example on the left here is for employees that present an I-94 with the printed number crossed out and the new number written on the form. You'll see that right here. The handwritten number is the employee's I-94 admission number. The example on the right is for employees who did not receive the paper I-94 upon admission. They would obtain their admission number by accessing the website shown right up here. Once they enter some personal information into that website, they'll be able to print out their I-94 information, which includes their admission record number, as referred to as their I-94 number. And you can see that. I know it's a little hazy on our slide here, but it's this admission I-94 record number. Now, if you need to see more examples of the different types of I-94 documents you might see, or to get more information about that automation initiative overall, you can visit CBP's website shown here, and they have a good Q&A section on there and some additional examples of those I-94 items. Okay, also found in Section 1 is the employee attestation portion. The employee must select one of the 4 work-eligible categories that we went through, whichever one that they fall within. They should only select one, and if the employee selects lawful permanent resident or alien authorized to work, they must also enter their alien registration number or their admission number, which is found on the I-94, and then also the date employment authorization expires if that's applicable. If the employee marks alien authorized to work and provides an I-94 number, the foreign passport number and country of issuance must also be entered. And you'll see that under number 2 here. And this is going to be available to those people who obtain their I-94 while traveling to the United States. If the I-94 admission number was obtained within the U.S., or if a person entered the country without a passport, the country of issuance field should be marked NA. And a refugee is a good example of an employee who would have entered the country without a passport, and therefore the country of issuance field would be marked NA. Also in Section 1, the employee must sign and date in the clearly designated signature area at the bottom. We have it highlighted in red there. And that should be done no later than their first day of work for pay. This can also be done before their first day of work for pay if a job has been offered and accepted by the employee. You cannot use the Form I-9 to pre-screen. However, if there's been a job offer made and accepted, you can go ahead and have the employee complete the Form I-9 at that time. Oh, one more thing I want to point out in this section is a 3D barcode. This space in Section 1, you'll also see it in Section 2, is a placeholder for future functionality that's not yet been implemented. It also brings the form into alignment with all USCIS form formatting. The final portion of Section 1 is the preparer or translator section. And this is a certification area where a preparer, translator, or someone other than the employee attests that the information provided is true and correct to the best of their knowledge. And this section is used if the employee is not capable of filling out Section 1 for themselves, and your employee must still sign the form in the employee's signature block even if a preparer or translator assists them. the preparer or translator who helps the employee must provide his or her name and address and must sign and date this certification portion of the form. The date your employee enters next to his or her signature should match the date that the preparer or translator signed the form. And then I mentioned earlier a stop sign. That was added to the bottom of Section 1 and is meant to help signify the end of the employee portion of the form. Okay, at this point, before we move into Section 2, I'm going to open the line for Janelle to go through some of the Q&A that have come in.
Yes, I've had a couple of questions having to do with the documents in Section 1. And actually the first question was, what if the employee chooses either 3 or 4, that's the lawful permanent resident or the alien authorized to work, and they also provide their Social Security card? What do you do? Well, you're going to want to go over the instructions again with them and explain to them that you, over the list of acceptable documents, that they need to choose which documents that they want to provide. If they pick the lawful permanent resident card, they have a green card, or they can go ahead and choose something from List B and C also. So again, you want to go over the instructions with them, explain that to them, and give them that choice to choose. Kind of a follow-up or in furtherance to that, the next question was, what if the employer requires copies of the driver's license and Social Security? Would that be a document abuse? And you want to be very careful that you're not over-documenting. So you're going to want to explain to that employee why you need those extra documents. It also might be a good idea to memo the file, or maybe even do a blanket memo or put that in your business practices. So if you are ever audited, ICE will know why you're asking for those extra documents and what you need those for. And of course, it needs to apply to all, not just to some folks. And I guess also as a final, if you want further guidance, to contact the Office of Special Counsel. Jenny did mention that you can call and get their advice. You can even remain anonymous, but to run that by them to make sure that you are not violating any anti-discrimination provisions. And I've just received some more questions, and I'll answer those through the notes and hopefully share those at the next break. Thanks.
All right, great. Thanks, Janelle. I've also gotten a couple of pop-ups. I just want to remind everyone to please send your notes to the USCIS Form I-9 host account. That's the account Janelle is sitting at, and she'll be able to look at and respond to your questions. So appreciate that from everyone. Okay, next we're going to step into Section 2 of the Form I-9. This is a portion completed by the employer and where that acceptable document review is recorded. You'll see that the instructions are highlighted at the top of this page, and we are going to discuss these on the next slide. What I want to draw your attention to right now is the box directly below the instructions. This box is where you must enter the employee's name as it was written in Section 1. And this will help identify pages if they get separated. Remember, you can choose to print the form double-sided to avoid the potential for those pages becoming separated. If you do so, this is still a required field. So make sure you're filling in this employee name in Section 2. There are also 3 entry blocks under the List A document column to accommodate situations where that List A document is actually a combination of documents. An example of this would be necessary for a foreign student or an exchange visitor. I also want to draw your attention to the circled blank in the certification area. This is where you'd put the employment start date. So that's going to be the day that the employee begins work for pay. This section's wording helps clarify that the hire date is the employee's first day of work for pay. Also keep in mind that the person at your company who does the document review must also be the person who signs and dates in Section 2. This is going to be true even if you have a designated agent acting on your behalf. As you'll see, and it may be hard to read here, but the certification area does say the person is attesting under penalty of perjury that they themselves has physically reviewed the documents provided by the employee. So it is very important that whoever's reviewing the documents is the person signing and dating Section 2. Now, going back to those instructions for Section 2, employers must complete and sign Section 2 of the Form I-9 within 3 business days of the date of hire for that employee. And remember, the hire date means the first day of work for pay. So as an example, if your employee begins working for pay on Monday, you as the employer have Tuesday, Wednesday, Thursday of that week to to complete the document review in Section 2 of the Form I-9. These are going to be your business days, not federal government work days. They're your business days. You may wish to document your business days in your company or personnel policy manual as well, so that there's no question about your business days. And then remember, employees must present unexpired and original documentation that shows the employer their identity and their employment authorization. Next, we're going to take a little bit closer look at where you'll be documenting that information in Section 2. So the employer or your authorized representative, if you've designated one, must examine one document from List A or a combination of one from List B and one from List C. The employee must be physically present with the examiner of the documents during that document review, and at that point you'll enter the title, the issuing authority, the number, and the expiration date, if there is one, of the documents in this portion of the form. You do want to try to be as thorough as possible when filling in this portion of the form. So, for instance, if you are entering a person's driver's license information in List B, that's one of those identity documents, you'd enter the document title on this line, the issuing authority, including the state. So my driver's license was issued in Nebraska, so we would say Nebraska Department of Motor Vehicles in the issuing authority. You want to make sure you include the state that it was issued in as well as that issuing authority. The document number, and then the expiration date of the document if there is one. Now, you are allowed to use abbreviations in the document review portion of the form as long as they're widely known or widely understood abbreviations. Some examples of that would be state abbreviations. So back to my List B document, NE for Nebraska. Other examples would be DMV for Department of Motor Vehicles, DHS for Department of Homeland Security. Just keep in mind that if it's not a widely known or understood abbreviation and you are questioning the use of it, an auditor might question that as well, and it might just be better to write out the words. If you do get audited, you won't be sitting there with the auditor to explain what was meant by that abbreviation. So if there's any question, you might just want to go ahead and write out the full word. You can also find more information about using abbreviations on our I-9 Central website under the link Completing and Correcting Form I-9, Avoiding Common Errors. I'll show you where to find that when we visit the I-9 Central website following the webinar today too. I also mentioned that there are additional blocks in the section where you input List A documents. We provided this example on the slide to help illustrate when that extra block under List A is actually needed. So if an employee is a student or a foreign exchange visitor who presented a foreign passport with an I-94, the employer should also enter in Section 2 the student's Form I-20 or their DS 2019 CVIS number and the program end date from that Form I-20 or 2019. The Form I-20 is the Certificate of Eligibility for Non-Immigrant Students, and that's what's shown on this slide. You can find other examples of the I-20 and the DS 2019 on page 59 of the M274 handbook. So if that's a category that you work with often, you might want to go back and review those samples for more information. Now, as far as the genuineness and photocopies of documents, we really do not expect an employer to be a document expert, but you must accept and physically examine each document to determine if it reasonably appears to be genuine and relate to the employee presenting it. If you determine that the document does not meet these requirements, you should allow your employee to present other documentation from the list of acceptable documents. Again, the documents you accept must be original. Photocopies are not acceptable. The only exception to that rule is a certified copy of a birth certificate. And that's going to be the one with that stamped raised seal indicating that it is a certified copy. And all documents must be unexpired. In certain circumstances, employers must accept a receipt in lieu of a List A, B, or C document as temporary proof of employment authorization when that document was lost, stolen, or damaged. Basically, they must have had it unexpired in their possession at one time. At this point, they're providing you a receipt because they've applied to replace that unexpired document. The receipt you accept must be issued by the originating agency, and the employee must present you with the replacement document within 90 days of the hire date. There are two types of acceptable receipts that may not have a replacement document within 90 days, and this is because they're temporary documents. We've listed those at the bottom of this slide. You can also find them on page 4 of the instructions to the form itself. Those acceptable receipts are the arrival portion of the I-94 or I-94A with a temporary I-551 stamp and a photograph on it, or the departure portion of the Form I-94, I-94A with a refugee admission stamp. Now here we have a couple instances when a receipt is unacceptable. You cannot accept a receipt that's indicating the individual has applied for an initial employment authorization document or for a renewal of an expiring employment authorization document for Form I-9 purposes. This is not acceptable. Remember, if it's a receipt, it must have been for a lost, stolen, or damaged document. And then finally, if that employment with this individual is going to last less than 3 business days, a receipt is not allowable. You must see an original document. You may choose to make photocopies of the employee documentation presented to you for Section 2. This is not a requirement of the Form I-9 itself. It's actually more of a business practice decision on the part of the employer. However, we do like to inform employers that the ICE best employment practices do suggest that employers maintain copies of any documents accepted as proof of identity or employment authorization. And that's simply because if you're ever audited, those document copies would be available to assist in the audit. So if an auditor has a question about something the employer input into Section 2, or maybe they can't read that, they could go back to the document photocopy and see exactly what the employer saw at the time of hire. And it could mean a difference between a fix-it ticket or a fine. So they do list that as one of their best practices. Now, if you choose to make photocopies and you're making this one of your business practices, you must do so for all employees, regardless of their actual or perceived national origin, immigration, or citizenship status, or you could be in violation of those anti-discrimination laws that we went through earlier. I know that's kind of a resounding theme throughout this presentation, but it does apply to the Form I-9. You want to make sure that you're being consistent and treating everyone equally. You're not being selective in your processes. And then also, if you do make photocopies, you still need to fill in and complete Section 2 of the Form I-9. Making photocopies of the acceptable documents does not take the place of completing and signing Section 2 of the form. And if this is a new practice at your company, maybe you weren't doing it in the past, but you want to go ahead and start doing this now, you can memo your personnel policy file indicating that as of X date and time, you'll begin making photocopies of the acceptable documents presented to you by the employee. And then from that date forward, make sure you're being consistent and doing so for all new hires. Moving on to Section 3 of the Form I-9, this is the portion to be used for re-verification when an employee's temporary employment authorization is expiring. And you can find expanded instructions on page 5 of the instructions to the Form I-9 regarding re-verification. For re-verification purposes, employers can either complete Section 3 of a new Form I-9 or Section 3 of the previously completed Form I-9. Now keep in mind, if there's a more current version of the Form I-9 at the time of re-verification, you must complete Section 3 of that newest version of the form. And remember, as I've mentioned a couple times, the most current version right now is the one with the revision date, March 8, 2013. So any new pages of a Form I-9 completed during re-verification must be attached to the employee's original Form I-9. So if you're completing Section 3 of a new Form I-9, you can fill in the employee's name at the top of the page in that field found under the instructions of Section 2, and attach that new form to the original Form I-9 of that employee. That way you're keeping the historic documentation and you've got your re-verification completed in Section 3. Employers can also choose to use Section 3 if you have a rehire who's been hired within 3 years of the original completion of their Form I-9. This is a choice or an option on the part of the employer. USCIS does recommend, however, completing a new Form I-9 for all rehires, but you do have the option of using Section 3. And then also, regarding biographic changes, in the case of a rehire or a re-verification, if an employee had a legal name change, that biographic change, maybe they got married or divorced, changed their last name, you must record the employee's legal name in the space provided in Section 3 of the Form I-9. So right up here where it says new name, that's where you would record that name change. Now, if you learn of a legal name change at the time other than during a rehire or re-verification, USCIS does recommend that you update the Form I-9 with that new name in the space provided. That way you're maintaining correct information on the Form I-9. And in either scenario, whether it's a rehire, a re-verification, or just someone that's working with you that you realize that they had a name change, you should take steps to be reasonably assured of the employee's identity and the veracity of the employee's claim that they had a legal change of name. And those steps might include asking the employee for the reason of their legal name change and to provide documentation of a legal change of name to keep with the Form I-9. Again, that way your actions are well documented if the government does ask to inspect your Forms I-9. Now, I know we went through a lot of information on re-verification. You can find more information about those biographic changes on pages 23 and 24 of the Handbook for Employers. And also regarding temporary work authorization re-verification on page 12 of the Handbook for Employers. And when I take you to the I-9 Central website, I will show you where you can find and download that handbook. This chart was put together to help an employer decide when re-verification is necessary of a temporary work authorization. So starting at the top, you do not re-verify if an employer originally presented you with a U.S. passport or passport card, a lawful permanent resident card, which is the Form I-551, or any of the List B documents. And you might ask why the List B documents are included here, and that's because those are identity documents. So those do not require re-verification. We often get questions about the driver's license. When that expires, do we need to re-verify? A driver's license is a List B document, and therefore you would not re-verify the driver's license or any of the other List B documents. Now, there are a couple of re-verification exceptions for permanent residents. Those are shown in the second row down, and that is to re-verify if an employee presented you the Form I-94 with a temporary I-551 stamp or a foreign passport with a temporary I-551 stamp on a machine-readable immigrant visa. In those instances, you would re-verify. And then finally, you would usually re-verify when employment authorization document from either List A or C has an expiration date. And again, you can find more information about re-verification of temporary work authorization on page 12 of the M274 Handbook for Employers. Okay, moving on to correcting mistakes. I mentioned this earlier, and if you discover you have a mistake on a Form I-9, you may correct the existing form or prepare a new Form I-9 to make that correction. If you choose to correct the existing Form I-9, you simply want to line out the incorrect portion, enter the correct information, and then initial and date that correction. You should never use whiteout on the form or redact any information on the form with a blackened out line or a blackened out area. You don't want to have the appearance that you're trying to hide something. So simply line through that incorrect information, input the correct information, and initial and date it. If you choose to do a new Form I-9, you do want to retain the old form so that you have that historical documentation, attach the new to the old, and then it's a good idea to also attach a short memo indicating the reason for your action. And then finally, if you're missing a Form I-9, you want to immediately provide the employee with the most current version of the Form I-9, give them 3 business days to provide you the acceptable documents, and then do not backdate the form. And to go into this in a little more detail, when we're saying don't backdate the form, that's in those signature blocks. So let's say, for instance, the employee had a missing Form I-9. You give them the Form I-9. They complete Section 1 today. They should use today's date on their signature part. The employer, when you're doing the document review, filling out Section 2, you should use that date in the signature line. The only date that's going to be in the past is their original hire date, because obviously this form wasn't done at the time of hire or it was misplaced, but you do want to indicate their original hire date on that certification line in Section 2. Also, with missing forms, it's a good idea to attach a memo, and this will document your actions for proof of compliance and show good faith on your part. Okay, moving into storage and retention. The Form I-9 must be on file for all of your current employees who were hired after November 6th of 1986. You can store those forms in any way that meets your business need as long as it's done securely and as long as you can make those Forms I-9 available within 3 days of an official request for inspection. And that official request for inspection could come from ICE, which is the enforcement side of the Department of Homeland Security, but it could also come from the Office of Special Counsel or the Department of Labor. If your business practice is to make photocopies of the acceptable documents, you should store those document copies with the appropriate Form I-9 and then ensure that only authorized personnel have access to your stored forms. We all know there's a lot of personally identifiable information on the forms. You wouldn't want that to fall into the wrong hands, so just make sure that they are kept secure. We do have a retention rule. Now remember that because the Form I-9 has to be on file for all current employees, you'll only use this formula once the employee is no longer employed by your company, once they've left the company. The rule states that the Form I-9 must be stored for 3 years after the date of hire of an employee or 1 year after the date you or the employee terminates that employment relationship, whichever of those two is later. So in our example here, John Smith was hired on November 1st of 1993. On July 5th of 1994, the employment ended. So we'll add 3 years to his hire date to come up with November 1st of 1996, 1 year to his termination date to come up with July 5th of 1995. The later of the two is going to be our retention date. So in this example, November 1st is our retention date. Okay, I think before we talk about E-Verify, I'm going to open the lines up again for Janelle to go through some of the Q&A.
Okay, lots of questions and topics that I believe Jenny already covered, but I'll just briefly touch upon them. The date format, it needs to be in that American format, the month, day, year. The use of NA, should it be N/A or N-A? The common way that you see it is an N/A. If you get into the N-A, it might be interpreted differently, so I would stick with the N/A or even write it out. Received a couple inquiries about pre-population, and we do have a policy response in regards to that. DHS regulations require that the employee complete Section 1 of the Form I-9. Employers can offer the employee electronic tools to facilitate the Section 1 completion process as long as this regulatory requirement and the regulatory requirements for the electronic generation of the Form I-9 continue to be met. And they strongly encourage you to stay within the requirements of the 8 CFR 274A-2, subsections E through I, to make sure that you are in compliance with the regulations, or you do risk the potential liability for violations of violating Section 274A of the INA. Further with that, when an individual other than the employee completes Section 1 of the form, then the prepare or translator certification portion of Section 1 must be completed. Anyway, we've had a lot of inquiries about that, and I sent everybody the policy response to those who asked that question. Okay, moving on to what constitutes a business day. They were hired, well, I want to go back. Your business day is going to be your business day, and it's going to be your operational business day. So if you are a company or a business that's open 7 days a week, but your office hours, your business office hours are Monday through Friday, you are up and working 7 days a week. When it comes down to a payroll, I know, like with us, it always starts on a Sunday, even though you're physically not there till Monday. Again, it's going to be your operational business days. Making corrections, I believe Jenny went over this. The questions were coming through with who is able to make the corrections on which section. Section 1 is completed by the employee. If there are any corrections that need to be made in Section 1, the employee needs to make that correction. If they are no longer with you, you're going to want to memo or document that file indicating that you were unable to update it because they're no longer with you. Sections 2 and 3, the employer can complete. We've mentioned that use of that memo, and we can't emphasize that enough. If you have a question or you think someone is going to question it, go ahead and memo the file. You can put a note in the file. I wouldn't put it on a napkin, but some type of documentation that you are explaining the situation, and basically that memo is going to speak on your behalf. If you are ever audited, you will not be sitting there with the auditor explaining to them step by step of what happened, nor could you possibly remember everything that happened. So the use of the memo, go ahead and do that if you are questioning it or you think someone will question it. Also along the lines of corrections, in Section 2 and 3, does it have to be the person who actually completed it first? No, you can designate someone to do that for you. You want to make sure that they are completing and following all the duties and responsibilities of the person who completes Section 2 and 3, and also in making those corrections. Another question has to do with completing the Form I-9. Once there's been a job offer and acceptance, yes, you can go ahead and have that form completed. Actually, the hire date can be a future hire date, also up to 365 days in the future. The name change, I believe Jenny went over this. There's been new policy on this. In the handbook, pages 23 and 24 go over how to handle a recording of the name change for an existing employee. You are now, you can ask for documentation and keep that with the Form I-9. And basically you want to make sure that you want to take steps to be reasonably assured of the employee's identity and the veracity of the claim of their legal name change. And I've had a couple more come through, and I'm still working on those. So again, thank you so much.
Okay, thanks for those questions, and thanks for providing the answers, Janelle. Okay, we're going to move into E-Verify now. Before we do, though, I just want to mention that E-Verify does not take the place of the Form I-9. Signing up for E-Verify is kind of an electronic extension of that Form I-9. You must still follow the Form I-9 rules and retention rules regarding the Form I-9, even once you've enrolled in E-Verify. But for those of you who are not familiar with E-Verify at all at this point, it is a fast, extremely easy and free internet-based system where an employer can electronically verify the employment eligibility of a newly hired employee. Federal contractors are also allowed to verify existing employees who are assigned to work on a qualifying federal contract. I always pause here because that's a very unique category of employers. They are the only ones allowed to verify existing employees. All other employers are limited to their newly hired employees. E-Verify is operated by the Department of Homeland Security in partnership with the Social Security Administration. We have many goals at E-Verify, and some of them are shown here. We want to help reduce the unauthorized employment in the United States. We want the system to be quick and non-burdensome to employers while helping to minimize verification-related discrimination and protecting civil liberties and employee privacy. Here we have a little schematic of how this all works together. Information from Sections 1 and Section 2 of the Form I-9 are keyed into E-Verify. E-Verify then queries the Social Security Administration records and the Department of Homeland Security records, and literally within a few seconds comes back with an initial result as to that person's employment eligibility. The initial results you're going to see in E-Verify are shown at the bottom of this slide. We've got employment authorized. Of course, that's a final result, and it means that this person checks out. They are authorized to work in the United States. The next two are shown in yellow because we're trying to indicate here that they are not a final result. They're more of an interim result in the system. An SSA TNC stands for Social Security Administration Tentative Non-Confirmation. And what that means is that there was an information mismatch within this person's records when we reviewed what was entered into E-Verify with the records at Social Security. There's something that didn't match up. A DHS verification process indicates that the Department of Homeland Security is looking at this case, but we need a little more time before we can give you a final result. If you receive either of these two responses in yellow, it does not mean that you can take any type of adverse action against the employee. It's an interim result. It's not a final response in the system. Now, if you receive either an SSA or a DHS tentative non-confirmation, the employee is given 8 federal government workdays to resolve that discrepancy if they choose to. Now, after 10 federal government workdays, E-Verify is going to update with a case status for that person to the employer. So you're going to check back in E-Verify, and you'll see one of the following responses. Again, we've got employment authorized, the one in green at the top here. Their person's good to go. The next three are interim results still. They are not a final result in the system. We want to give you a case status update for this individual, but it's still not a final result. So again, no adverse action should be taken based on any of these three responses in yellow. Now, the last two in red are final results. A DHS no-show indicates this person said they were going to contest and try to resolve that discrepancy, that tentative non-confirmation, but they never did so. They didn't show up within that 8 federal government workday time frame. A final non-confirmation indicates that we reviewed records for this person. All records were reviewed. There's nothing indicating that they are legally able to work in the United States. If you receive either of these two responses in red, you can terminate employment with that individual and then close the case in E-Verify. Now again, if you're interested in more information about the E-Verify program, I'd suggest that you visit our E-Verify website or join us for an E-Verify overview webinar where we'll go through the employer responsibilities when using E-Verify, as well as how to enroll and how to deal with those different case results. So moving on to some resources available to our employers. We've got I-9 Central. This is the one-stop shop for all things Form I-9. It's available in English and in Spanish, and I am going to take you to that website when we finish the presentation today. We've also made some direct links here for you to the Form I-9 itself and the M274 Handbook for Employers. These are actually live links. So when you get a copy of the presentation today, you can go back to this slide, click on that directly, and it'll take you to the resource that you are looking for. We have an employee hotline available, also available in English and Spanish, and this was created to respond to employee questions or issues. They can contact us and choose from one of 5 automated options. Once they make their selection, they'll be taken to an operator who can assist in answering their questions. Now, Janelle and I are both part of the outreach team here at Verification, and we can provide any of these services to assist employers and associations, including speakers or panel participants at your events. We can provide an exhibit booth for the Form I-9, E-Verify, Self-Check, for SAVE, any of the programs that we support here at Verification. We can also do free webinars, very similar to the one that you're on today, but we can also do customized webinars. So if you have a large organization or a large company where you have many employees that need to be brought up to speed all at one time, we can customize a webinar to specifically meet those needs. In addition to that, we can provide content for your newsletters and authorization to use the E-Verify logo and seal. We're also very proud of our customer service here at Verification. We did receive the highest rating for customer service of all federal agencies the last 3 years. So please use this resource. We have very well-trained operators who are responding to our hotline calls and our emails that come in. The hotlines are shown at the top, email addresses. We've also got our websites that are constantly being updated. And you can now follow us on Twitter for live updates as well. Now, immigration law can be complex, and it's not possible to describe every aspect of the process in a 1-hour presentation. Today we're just trying to give you some basic information to help you become generally familiar with the rules and regulations. If you have the need for more information, please visit our website at www.dhs.gov/e-verify. And my last slide is just requesting comments on our webinar. We love to have your feedback. We'd like to know if we're doing a good job on the webinar, it was helpful to you, or maybe if you'd like to see something else. Maybe we didn't cover something that you wish we would have. Please send us an email about that to Francine Hill, and make sure you include the date, time, and the topic of the webinar that you participated in. Okay, at this point, I'm going to take everyone to the I-9 Central website and open the line for Janelle to go through some final questions.
Okay, just the last few questions. The one came across, what would be the document title for a Social Security card, and it is the Social Security card, and you can abbreviate that, SSC. Also, I just want to touch upon briefly about the issuing authority. You're going to want to look on those documents. Sometimes if there's a seal, it's around the seal, but not necessarily. That's the issuing authority. Look at the front and the back. I know with Social Security cards, currently the issuing authority is the Social Security Administration, but they have also had different issuing authorities over the years. So you want to make sure that you are looking for the issuing authority on those documents. The next question had to do with, do we have an example of a memo that we can share, and we do not. However, I do want to also send you to the ICE website, and actually under the ICE image website, there's a list of best employment practices that have other good suggestions there too. But in creating that memo, you can make it as formal as you want, but I think what's really important is that you are documenting your actions and you have dates or the situation. We conducted an internal audit on this day. This is what we found, and this is how we handled it. That type of situation. Or if you need to explain who your designated agent is, you can go ahead and do that too. And again, it can be a blanket memo if this is going to cover all of the employees. For instance, you're just starting to make the business practice of making copies, that would be a blanket memo, or if it's an individual memo. Either way, it can be a memo or a note. Again, I wouldn't put it on a napkin, but some type of documentation that you can provide in that file to provide that information for the ICE agent if you are ever audited. And I think that's it. And thank you very much.
Okay, thanks, Janelle, and thanks everyone for sending in those questions. What you see in front of you now is the I-9 Central homepage. And again, this is kind of our one-stop shop for Form I-9 information. From here, you can find a lot of great information about completing the Form I-9, correcting the Form I-9, what documents you can accept. I'm going to take you to a couple different spots on here that we have found to be pretty helpful for employers. The first one is under Complete and Correct the Form I-9. I'm going to click on the plus sign next to that. And I'm going to go down to Complete Section 3, Updating and Re-Verification. We've been getting a lot of questions about those biographic changes and completing Section 3 for a rehire. You can find more information about all of those scenarios under Complete Section 3, Updating and Re-Verification. So some good information there. And regarding those name changes and identity information changes, if you scroll down to the bottom of that section, I know your screen doesn't follow mine, so you'll have to scroll down on your own. But at the bottom of that page, there's some additional information about recording those changes on the Form I-9. Okay, moving down then to acceptable documents. I'm going to go into that link. There's a place on there where it talks about who is issued this document. So we have put together a nice little matrix about what work-eligible category of individual receives which documents. So this is kind of a helpful matrix if you're wondering if an individual receives a certain type of document, they fall in this category, you can go to this matrix and find out specifically if they are issued that type of a document. Another link under that acceptable documents is examining documents. We get a lot of questions about maybe differences on the form or what the employer wrote on the form versus their document itself, what's written on the document. This is another table where we've put together information about maybe someone provided you a document that looks to be genuine, but they wrote their name differently on the Form I-9. What do you do? So you can find some helpful hints and additional information in this chart here regarding those types of scenarios. And then I will also direct your attention to, I'm going to take you back to the I-9 Central homepage. And if you scroll down on this page, at the very bottom of the right-hand navigation bar, there's what looks to be the front of a book cover. That is a handbook for employers. So you can click on that. It's a PDF document, and you can go ahead and download or print out that handbook for employers. And I know Janelle and I both referenced information from this handbook. So it is a helpful guide and tool for employers to use when you have questions about how to complete the Form I-9 for a category or you're wondering a certain question. That manual can be very, very helpful to you regarding those situations. Also found under the other USCIS links on this home page, there's a direct link to the E-Verify program, which I talked a little bit about. This is where you would go to enroll in E-Verify. Like I said, we also do free webinars regarding the E-Verify program. So if you're wondering or wanting to learn more about E-Verify and how to enroll, you could join us for a free webinar. And I think with that, we are going to go ahead and conclude today's Form I-9 overview. Again, we appreciate everyone for joining us today. And I know Janelle may be working on a couple more questions, and she will be responding to those through the notes. At this point, we are going to end the audio portion of today's webinar. And again, thanks for joining us. Have a great afternoon.